Salutations to all our future judges. In this video, we are going to see the Code of Civil Procedure 1908, Part 13, Sections 51, 52, 53, 54, 55, 56, 57, 58 and 59. If you have not seen the earlier part, that is Part 12, I am providing the link in the iCard. You can click that and watch the video. If you have not seen the earlier parts and if you want to see all the earlier parts, I am providing the link of the playlist in the description. You can click that and watch all the parts provided under this particular series. We are going to see procedure in execution. Section 51 speaks about the power of court to enforce the execution. In general, when we try to execute a particular order or a decree, it is absolutely difficult. So, for executing this, court has certain powers. This particular section explains what are the powers the court has. There are certain conditions and limitations in this particular section which we need to know. It can be prescribed if need be. The court may apply all these conditions and the limitations if need be. And this enforcement is based on the application of the decree holder. So, the decree holder has to file an application before the court to execute an order. A. Imagine a decree where the court is giving a direction to deliver a property to defendant. In that case, this plaintiff will not file an execution decree. On the contrary, the defendant will file an execution petition before the execution court requesting the execution court to execute that particular decree. In that, the plaintiff was directed to hand over the property to the defendant. So naturally, the court will ask or direct the plaintiff to deliver the property as given in the decree. This is 51 subclause A. Now let us move to 51 subclause B. The court can attach a property and sell it or sell it without any attachment. These two things the court can do. The third one, that is 51C. The court can arrest and detain a person in prison, and the maximum period will be as provided in section 58. The next one, that is 51D, simply you can understand that receiver is a person who takes a property and maintains it and sells it or attaches it or does anything which is required to execute that order with respect to any property. The last one, that is 51E, is the court can grant any nature of relief as may be required in that particular situation. There is a proviso which we need to understand. If there is a decree which is for payment of money, imagine a person has to pay some money he has not paid and the plaintiff has filed a suit against that person who is not filed, that is the defendant, and the court says the person has to pay the money and he has not paid the money. In that case, the court is giving an order saying the defendant has to pay money to the plaintiff. Plaintiff goes for execution. In that case, the court will ask the person, that is the defendant. In EP petition, he will be the judgment debtor, or simply they call it as JD. So the court will ask the JD as to why you are not paid the money. An opportunity will be given to the JD, asking him why he should not be sent to the prison. Is there any reason from his side? And after that, after listening to him, the court will record this in writing. And if the court is satisfied that judgment debtor has an objective to obstruct or delay the execution of the decree. Imagine we are filing a case and we are obtaining an order in our favor. We are trying to execute that order and the person who has to pay the money or who has to do something is obstructing us from executing that particular order. Then what can be done? In that situation, the court can arrest that person. But under this particular category, there are two important things which we need to know. One, if the court is feeling that the judgment debtor might abscond from the local limits of the court. For example, imagine the case is being held in Delhi and the person is trying to go out of Delhi or is planning to come to Chennai or some other state or some other city. In that case, the court will try to secure him by way of arresting him. This is the first point. Let us move to the second point. Imagine I am filing a case against one party. In that, The main thing is I am fighting for my own property which that person has taken dishonestly, and I am filing a case. While the case is pending, this person he transfers the property to someone else dishonestly by hiding all these facts. Or if it is for a movable property, he has tried to conceal the property, or he is trying to remove that property or any part of the property. In all these three situations, or the fourth aspect is he has committed an act of bad faith. He has done something with bad intention, with a bad idea. In that case also, the court can detain that person in the prison. Imagine I am a multi-millionaire. I am having crores and crores of money. Every month I get income in crores. Whereas a person A has filed a case against me, which has been ordered against me in favor of that person, where I was directed to pay 1 lakh only. I am getting income in crores every month, but I'm not ready to pay that 1 lakh to that person, which is absolutely unfair. In that case, the court will try to arrest me because I'm having sufficient funds. Still, I'm refusing to pay the money. I'm neglecting and I'm refusing to pay the money. In these situations, the court will try to arrest me. Let us move to the C point. Imagine a scenario where I am having some money in a bank. I am having, say, some 10 lakhs in a bank. This bank is bound to keep my money safe. They are bound to account it. So what happens is suddenly that money vanishes from the bank account, from my bank account. So I go to the bank and say, like, see, what is this? I put 10 lakhs in your bank. The money is vanished. I don't know where it went. I have not used that money. Someone else had taken that money from my account without my knowledge, without my consent. Then in that case, it is the duty of the bank to tell you as to what has happened to that money. So under the fiduciary capacity, the bank is bound to keep and maintain the accounts. So if the judgment debtor is bound by a fiduciary capacity to account something, and if he fails to do so, and particularly with respect to the sum which is given in the decree, in that case what will happen is that the court will try to arrest that person. Now let me come back to my earlier statement. Imagine there is a property which cannot be attached by way of execution. There are some properties which are exempted from attachment in an execution of a decree. In such a case, calculation of means, that is the source to pay the money to the decree holder, will not be covered under this. For example, I am in a trust. I am holding the post of a manager in a trust. This trust is getting plenty of money. Say the money is coming from various sources and it is in crores. In that case, I am the person who's holding that money or having the authority to spend that money. But actually, I do not own that money. I have to spend that money for the purpose of the trust. It is not my money. In that case, this money cannot be attached for my liability. That is very important. This cannot be counted as my means of money. Let us move to the next section, which is section 52. Enforcement of decree against legal representative. If there is a legal representative who is acting on behalf of another person in a case, in that case, if a decree is being passed, in that case, what will happen? And particularly, if the decree is for payment of money, particularly, that is very, very important here. That decree should be for payment of money. That is the first point. Second point is that that payment of money should be out of the property of the deceased. Imagine, deceased has a house in a very big city. The court is saying, sell that house and pay the money to one Mr. B. That is the decree. And this case is being represented by the legal representative of the deceased person. In that case, the court can execute this order by way of attachment and sale of that particular property. Let us move to subsection 2 in section 52. In this, there are two aspects which we need to understand. Imagine there is a property and now that property is not available with the judgment debtor. It is not in his possession. First point. And after this, he has to show to the court the reason why that is not in his possession. This is actually the property of the deceased. He has to satisfy the court as to what is the reason for not having this particular property in his possession. If he fails to do so, then the court will presume, or the court will ensure, that this particular order is executed against the judgment debtor as if it has been personally passed against him. Imagine there is one property A, which is the property of the deceased. That property did come to me, but after that, due to some reason, that property is not with me. Then I have to say to the court that this property was with me, then subsequently there was some debts for which I sold this property and paid that money to them, and the value of the property is 1 lakh and the debt was around 1 lakh. So I don't have any property now. So he needs to explain to the court as to what has happened with respect to that particular property which is not in his possession now. Let us take another scenario where the court is passing an order against the judgment debtor saying that this property will not be in your possession anymore. The court is saying you get out of this possession. In that case, he will explain to the executing court that the other court, maybe a high court, maybe a supreme court, or any higher court, has stated that I should not be in possession. So this property is not in my possession and I am really helpless. So all these facts he need to say before the executing court and satisfy the court. Section 53 is actually very specific. It says about the liability of ancestral property. This particular section applies only to section 50 and 52. They can ask a question here. They can very clearly say section 53 of Civil Procedure Code applies only to sections, first option, 50 and 52. Second option, section 51 and 53. Third option, 50 and 45. Fourth option, 52 and 43. They can ask a question like this. So section 53 is applicable only to section 50 and 52. This is very, very important. Please understand this. The next is, if there is a property, imagine that person is a Hindu. He is governed by the Hindu law. In that case, this particular person has to pay some debt and that person dies. Then this particular property comes to the hands of his son or other descendant, whomever it may be. In that case, if a decree is passed against that particular deceased Hindu, then this property shall be deemed to be the property of the deceased, and this legal representative or son or other descendant shall be equally liable as the person who deceased. Let us move to section 54. Partition of estate or separation of share. Let us take a scenario where there is a decree for partition of an undivided estate. There is an estate which is paying revenue to the government. In that case, if someone is filing a decree for partition of that undivided estate or for a separate possession of a particular share, in both these scenarios, the partition shall be made by the collector. Partition or separation, as the case may be, will be done by the collector or any gazetted subordinate of the collector. These two things. This collector can depute that person and get this done in accordance with the law. Trying to understand this in a simple manner, if there is a property which is paying revenue to the government, that property can be partitioned or a separate portion can be given only by a collector. Let us move to section 55. Arrest and detention. The basic thing which we need to understand is the court has got a right to arrest and detain a person under the orders rendered in civil cases. That is the first basic point which we need to understand. Let us move to subsection 1 under section 55. A question can be asked in the exam whether a judgment debtor can be arrested at any hour on any day. The answer is yes, subject to the provisos. Here you can see a person can be arrested at any hour on any day. That is the first important point which we need to understand. Second thing what should be done is he should be brought before the court. That is the second point. And the third point is his detention should be in a civil prison of the district in which the court ordering the detention is situated. That is the third point. And the fourth point is if that civil prison does not have suitable accommodation, then they'll be put in a place where state government has appointed for detention of such persons. There are some provisos to this which we need to understand. The first proviso is that if a person is to be arrested, he can be arrested between sunrise and sunset. He cannot be arrested after sunset or before sunrise, particularly in a dwelling house. That is the most important point which we need to understand. Dwelling house, you cannot go and arrest after sunset or before sunrise. Now let us move to the second proviso. Imagine there is a judgment debtor sitting inside a house. Whether the person or the authority who is going to arrest him can break open that door. He can. If the judgment debtor refuses or does not give access to go into the dwelling house. That is first point. Inside the dwelling house, if this authorized officer has gained an access and this particular judgment debtor is sitting inside a room, in that case, whether this particular officer can break the door of that particular room. The answer is yes, he can still do it. And there is another proviso to this, which is the third proviso. If that particular room, imagine there is a judgment debtor and his wife who is sitting in that particular room, and that wife is prevented by customs of the country to appear before the public. In that case, this officer will say to that lady, I'm going to break open this door. I'm giving you the liberty to withdraw from this room. You can go. I'm giving you reasonable time. In that case, that particular lady can go out of that room. After that, this particular officer can go and arrest that judgment debtor. Now let us move to the fourth point. In this fourth point, you will see that when the officer authorized to arrest the judgment debtor is going to arrest him, at that time, the judgment debtor is settling the amount. He is saying like, I have to pay this much money, I am paying this money, as well as the cost of arrest. In that case, the officer will release him at once. Let us move to 55 subsection 2. The most important thing in this particular section is that there may be people who are well-known celebrities or who are holding a high position in any government. In that case, if this person is going to, the authorized officer is going to arrest him, in that case, there might be a danger or inconvenience to the public. In that case, that arrest shall be carried on in accordance with the direction given by the state government or procedure established by the state government. Let us move to section 55, subsection 3. Imagine a scenario where a person is arrested in execution of a decree for payment of money and is brought before the court. Then the court will inform that particular person, that judgment debtor, that you have an option to declare yourself as insolvent. And in that case, he may be discharged. Provided, the most important thing is that judgment debtor should not have committed any act in bad faith. That is very, very important. And another thing is he should comply with the provisions of law of insolvency. In these two scenarios, the court can discharge him. Let us move to section 55, subsection 4. Imagine a judgment debtor is being arrested and brought before the court. That is the execution court. In that court, he is saying to the court that I am planning to file a petition for insolvency and I am ready to furnish the security to the satisfaction of the court. And that he has to apply within 1 month. They can ask this in the exam. This can be a one-word question. How much time is given for a person to apply for insolvency when he is a judgment debtor? The answer is it should be 1 month. And then he should agree that he will appear when he is called. In such a scenario, the court may release him from arrest. And in case if this judgment debtor fails to apply so and he fails to appear, then the court may direct the security to be released. The court will ask him to furnish some security. That security will be released. And then he can be committed to the civil prison if that security could not be released. Let us move to section 56. This section is very, very important. Many times they have asked question from this particular section. This section very clearly says that a woman cannot be arrested with respect to execution of decree for money in a civil prison. Let us move to section 57. Section 57 is also equally important. Let us try to understand this in a simple manner. If a person is arrested, subsistence will be given to him in civil prison. So in that case, this will be fixed by the state government. Let us move to section 58. This section 58 is also very important both for preliminary as well as main examination. They can ask questions from this particular section. Many times they've asked questions from this particular section. It's very important. Let us move to subsection 1 under section 58. If a person is detained in civil prison in execution of a decree, then if the money payable is not exceeding 5,000 rupees, then in that case he can be arrested for a period not exceeding 3 months. So if the amount is 5,000 rupees, the imprisonment cannot exceed 3 months. And where the sum of money is exceeding 2,000 rupees but not exceeding 5,000 rupees, in that case it shall not exceed 6 weeks. That is, the period of arrest cannot exceed 6 weeks. Now the question comes, what if the amount is less than 2,000 rupees? If it is less than 2,000 rupees, the person cannot be arrested or he cannot be detained in a civil prison. Let us move to 58 subsection 2. Imagine a situation where a judgment debtor is released from detention under this particular section. Then he cannot go and say to the court, see, I have been released from detention, so I should be discharged from my debt. That is not the case. Just because he has been released, it doesn't mean that he is discharged from the debt. He will still be liable to be rearrested under the decree of execution for which he was detained under the civil prison. So the simple remedy is he has to pay the money to get discharged from the debt. Now let us move to section 59, release on ground of illness. Let us see what subsection 1 under section 59 states. If a warrant is issued for arrest of a judgment debtor, that warrant can be cancelled on grounds of serious illness. This is the first subsection. Let us move to subsection 2 under section 59. If a judgment debtor is arrested, the court can release him if the court feels that the person is not in a good state of health or in a fit state of health to be detained in a civil prison. That is the second subsection. Let us move to subsection 3. Where a judgment debtor has been sent to the civil prison. He has been sent to the civil prison. In that case also he can be released by the state government if he has any contagious disease. He has an infectious disease. Then the next point, which is point B, by the committing court or any court to which that court is subordinate on the ground of his suffering from any serious illness. Let us move to subsection 4 under section 59. A judgment debtor, if he is released, can still be rearrested, but the period of his detention in civil prison cannot exceed the aggregate provided under section 58. Already we have seen section 58, so it cannot cross that period. Imagine a person can be arrested for 3 months. So he is arrested for 1 month, he is released. Then again he can be arrested for 2 more months. He cannot be arrested for 3 months again. So total cannot exceed 3 months. That is the point under section 59. If you like the video, please do press the thumbs up button and leave your comments in the comment section. And do subscribe the channel and also share the channel with your friends. Let us join hands together and contribute for a learned society. Thank you.